Hi all. So welcome back to the business law subject, and the topic for today is partnerships, right? We earlier we discussed about contractual agreements and things like that, and today we are going to consider about the partnerships, right? This is actually the partnerships which are related to the law of Victoria in Australia. But most of the Parliament acts and everything is made, or basically the regulations and rules made are made based on the Commonwealth rules, or known as, in Australia you have the federal government. So according to the federal government, all the states and the territories has to make their laws. So there, actually, we are going to consider about the laws in Victoria, where we are going to comply the laws, the basic acts in the through the Commonwealth regulations, right? So we'll discuss about the partnerships. Now, in a partnership, what do you mean by a partnership? A partnership can be defined as in a relation which subsists between persons carrying on business in common with a view of profit and includes an incorporated limited partnership. Now it's clear there are three types of things here. You can the definition tells you partnership is basically a relationship between the parties, or let's say the persons carrying on a business, right? So those are basically based on the business relationships and in common view of the profits, that is basically made on the profits view, right? uh, and includes an incorporated limited partnership. Okay, that is a limited partnership. They are limited, they are bound by the law, or even they are responsible for the capital that they have employed, and they are having a limited partnership there, right? No one can sue, let's say, in an event where the partnership has made a sort of a loss. So let's say, if they were if they are going to insolvent in a situation, so the partners, those who are in the partnerships, are not bound by the law to pay over the liabilities by disposing, or let's say, through their personal assets, right? Those are like limited partnerships. So the number of they have employed, like whatever the capital employed, that proportion has to be considered in settling the old debts and things, right? So the characteristics of a partnership is carrying a business with a common view of profit, and it's again, it's common, right? It's common for the partners, right? We'll move further. Now, carrying on a business, in the sense, business can be any trade, occupation, or a profession. It's like any trade relationship between, let's say, a transaction. It can be an occupation where partners are involving in a job, or else that can be a profession where some of the legal partners are there. If you can remember, basically when the two lawyers or two legal attorneys became together to form a partnership, that is basically their profession, right? So let's say L&M partners, legal attorneys, so that is a profession again, but it's a partnership, right? So that has the common view of earning profits through their business, and it's a case of business, and it is common for them, the partners, right? And there are so many things which distinguish between the partnerships, right? Now, see, distinguishing between carrying on a business and carrying a hobby. Now, carrying a hobby is not a partnership. Let's suppose that two friends have came together and they are doing a sort of a hobby activity. That is not a partnership, right? But to become a partnership, it has to be a business. Okay, it should be a transaction, or where it can be a trade, it can be an occupation, or else it's a profession, right? And then the second one is distinguishing between carrying on a business and preparing to carry on a business. Now, the discussions which are having on starting up a business between two parties cannot be considered as a partnership. It is just a discussion, right? Before, or let's say prior the partnership exists, right? So if they are continuing with a business, so that can be seen as a partnership. So no business, no partnerships. Discussions cannot be considered as a partnership, or let's say the meetings, or let's say the preparing, right? They cannot be considered as a partnerships. And distinguishing between the carrying on a business and carrying out a single venture, right? That can also be seen as, distinguishing between carrying on a business. Business is a partnership, but of course, when it comes to a single venture, which is owned by a single person, it's not a partnership, right? Okay. Then, business in common. Now, in business in common, in the sense it describes the rights and obligations that the parties do have in their relationship of partnership. Right? They have the mutually agreed rights and obligations from each to other, right? And then they have the shared profits of the business. So whatever the business that they do, their intention should be a profit. So the profit oriented businesses are gaining some profits, or it can either be loss, but those things has to be shared between the partners, right? So shared profits or losses on a business activities. Then the parties into the partnership should engage in the same business. Now, well, let's say there are parties called A and B. While A is engaging with the co-business, the B cannot get involved with another, right? So B has to be with A, engaged in the same business. So then only the partnership exists, right? So these are the conditions. Then, with a view of profit, we told it should be a business activity, it should be common into the partners, and it should be with a view of profits. Now, the original intention of the existence of a partnership should be the creation of profits. Okay. Then the partnership exists for commercial relationships, not for the not for profit or non-profit oriented businesses. Partnerships are not existing for not profit oriented or non-profit oriented businesses, or those are only for the commercial or merchant relationships. Okay. Then the creation of partnership. It's must to get to know about how you can create a partnership under the common law or the Commonwealth law in Australia. In creation of partnerships, that relates all the regulations and rules which are govern the partnership businesses existing in the in Australia. Is the legal regulation and rule is the Partnership Act, right? Now, Partnership Act governs all the states, right? Let's say it can be Victoria, it can be, right? Different types of states are majorly handled by this Partnership Act. Now, Partnership Act contains the rules and regulations which are imposed, or let's say which are defined by the Commonwealth regulations, right? And also, as you all know, there's a federal government, okay? So that is the supremacy of the legal legislation. Let's call it as preparation of legislative conducts, so that Commonwealth regulations are also included in this partnership acts, right? So all the partnerships acts which are in the particular states or even the territories should have to comply the requirements made by the Commonwealth Parliament Act of Partnerships, right? So the Partnership Act for the each and states provides the regulatory backgrounds for the decision making, dissolution and other matters related to the partnerships, right? There are three aspects known as decision making in partnerships, dissolution of partnerships, and other related matters like the fraudulent conducts and things like that will be governed by the Parliament acts related to the partnerships. So the Partnership Act governs those. Okay. Now, if the partners, let's suppose there are two people. Let's get a simple example of Thomson and Calculus, right? You may heard of the names, right? So Thomson and Calculus are two people, right? And the both are involved with the same business, and they wanted to name their business by their names. So if the names, or we call them as the true names of the two partners are Thomson and Calculus, they don't want to register their name as a business name if they choose their own names in the business name. Let's say Thomson and Calculus Partners, right? So they contain the name of the business contains their names, right? So they don't want to register it as another business name, right? Because they have their names in that. But of course, let's say Thomson and Calculus intends to name their business as let's say Mueller and Co, right? Mueller partnerships or Mueller, the legal partners. In that case, Mueller is somebody who is not into the contract of partnership, right? And also it's a name, just a name, right? Or even they can use the first letters of their names, right? Thomson and Calculus, T and C, partners. It doesn't contain their name. So because of that, they have to provide and they have to, register that particular name under the regulations of the business names. Now, in registering the business names, it doesn't matter whether you have registered or not. The other ones can use your name as well, because there's no such a, let's say, you are not, by registering with the Business Name Acts, you are not restricting another party to use that particular name into their businesses, right? There's nothing called like that, because no one is restricted with name registrations. Okay, once you have registered the name, someone can use your particular business name into their business as well, right? There's no harm. I mean, there's no legally what you call as the restriction on using that particular name, which is almost registered. But if you want to protect that particular name only for your business, you can go for the provisions made by the Trademarks Act in 1995 under the business trade name registrations. So if you have registered your name of the business under the business trademark registrations and the provisions made by 1995 Act, so you can register your business unique for your business, right? Then you will get TM, that is called trademark, or you can display under your name, like next to your name you can display as R, which is registered again, right? To imply or to express that, sorry, not to imply, to express that your business name is registered. So that will restrict someone else from using your own business name to their businesses. Okay, that is the nature of it. And going to the statutory rules which governs the partnerships, of course we can see Partnership Act of 1958 subsections and things like that, right? Under the Partnership Act of 1958, that is related to the Victoria States, Section 6 contains the statutory rules that distinguish the partnerships, right? As well as the Section 6(3)(a) recognizes the creditors often secure the repayment of debt by agreeing to take a proportion or a portion of annual profits until the debt is repaid. So in that case, whatever the proportions that they have agreed in the partnership contract, they have to follow it until the repayment, or let's say until the debt is repaid, even though they have earned more profits, but still they have to give a provision, or they have to remain the proportion of debts, the debt repayment in their particular partnership to pay over the liabilities to their creditors. That is governed by Section 6(3)(a). And then when it comes to Section 6(3)(b), that reflects the common situation that the employees are often offered a share of profits, right? If you have heard, some of the partnerships or some of the companies even, they share some of the profits with their employees as to give them as an incentive, right? To to appreciate their contribution to earn that sort of a profit, right? In that case, in partnerships, the employees are becoming as the partners of this business as they are getting rewarded with a profit portion, right? That particular part is governed by the Section 6(3)(b) of the Partnership Act of 1958, and it contains the employees are often offered a share of profits as an incentive as a part of their overall remuneration package, right? But to refrain, they become the partners of this business. There are so many provisions made by the Partnerships Act of 1958 under Section 6(3)(b). Then Partnership Act of 1958 in Victoria, Section 6(3)(c) covers all the repayment and the payment of annuity to payment of annuity to widower or child of a deceased partner. Let's suppose that in some case a partner can be deceased, right? In that case, even though the partner is deceased, but still the payments of let's call it as widow payment, right? Annuity to a widow, that has to be paid by the partnership if the partnership is existing. So there, the provisions related to that particular payments are covered or governed by Section 63C of Partnership Act. Then, in Section 63D, it covers all the designed, like it is designed to protect the bona fide creditor who finances the project in return for share of the profits, right? So that is to protect the bona fide creditor, or let's say a real creditor, right? It's not a nominal creditor, it should be a real creditor who finances the project, okay? And then Partnership Act in 1958, Section 63E represents a fairly common way of securing payment for the sale of a business, right? These are the statutory rules which are relevant to the partnerships in Australia. Okay. Then, rules governing the relationship among the partners. So what are the rules governing the relationship among the partners? We told you, it should be a business relationship. It should be common to the partners, as well as it should be oriented on the profits. Okay. Then there are 3 regulations and rules, principles which governs the relationship among the partners in partnership. Now, there are 3 types of rules. What are those? Contract created in the partnership. That is basically the partnership agreement, right? So there are so many terms and conditions and the legal obligations and regulations to govern. All these things are included in that particular contract between the partners. So that is one thing where the rules govern the partnership, that is contract to the partnership, or contract created in the partnership. Then the next one is the most important thing, that is Partnership Act, right, which is made by the Commonwealth government, or let's say the federal government, as well as which complies like the local government, or let's say the state government acts, which complies the Partnership Act made by the Commonwealth regulations. And then the third one is law relating to the fiduciary responsibilities of the partners. Okay, there are 3 aspects, so those are governed in the partnership, or let's say the relationship among the partners. Then partnership contracts may contain they are containing the rights and responsibilities, as I said before. They contain the rights and the responsibilities of the partners, right? So partners are having the rights of, a partner has a right to sell the firm's trading stock, right? Whatever the trading stock they can sell as being a partner. And also a partner has the right to buy stock of a kind usually used or traded by the business, that are not new, right? That should be traded or agreed to trade in the business, right? And then a partner has a right to receive the payment owing to the partnership and to give a valid discharge, right? If you look at the discharge of the contract and the performance of the contract, you can remember, I think, right? A partner has the right to receive the payment, right? On behalf of the partnership, a partner is having the right to receive the payment, and also in return the partners has right to make the payment, right? Like make, accept and issue the checks for the negotiable and other instruments for the payments, right? They can make it. And then finally, a partner has the right to pledge the firm's credit for the purchase of stock. Okay, so these are the rights and the liabilities of the partner, basically the rights of the partners in the partnership contracts. And then there are some of the duties according to the Partnership Act which the partners can perform, right? Now these are duties which are rigorously they have to perform these things, right? So partners' duties are duty to make disclosure in the sense they have to reveal everything, right? Now between the partners, let's say in a case where the partners doesn't know to the business transactions done by each other, so that makes a sort of a dispute, or that makes a sort of a conflict between the partners. So ultimately the partnership will be dissolved, or even the partnership will be breached, right, in case. So because of that, it's a partner's duty to make the disclosure on their business activities, right? partners to make the full and frank disclosure of all it matters, right? Basically, to the partners of each other, right? Then duty to account for benefit derived from dealings with partnership. Duty to account for benefits, right? Prohibits a partner from having dealings with the partnership without disclosing the nature of those dealings to the other person. Other person in the sense, other partner it can be. Then duty to account for use of partnership assets, right? Those are prohibits a partner from deriving a benefit from the partnership name, property or business connection without the consent of other partner. Now you cannot use, if you are a partner, you cannot use the organizational assets, brand name, it can be one of the properties of you have, right, to make sort of personal business dealings, right? So that, that accounts you, then that is your responsibility and your duty to account for use of the partnership assets, right? You cannot misuse. And then duty to not to compete with partners, right? That is basically, that's there's a possibility of these things on the conflict of interests. Now, if you are a partner of some partnership, and if you are a member of one of your competitive company, so that creates you, that makes you the conflict of interest, where if you have worked for the business, the both the business secrets of the both organizations, or known as the one, your partnership and the company. So if you are going to reveal some of your confidential details in that particular organization, right, you will make a competition automatically, so which creates and which violates your duty on not to compete with your partner, right? So it's a fiduciary duty, and it's fiduciary duty not to compete with your partners by protecting your the conflict, not allowing you to perform the conflict of interest, right? So these are the things, the partners' duties. Then the liability of the partners to the third persons. What are the liabilities? Now it can be a personal liability, in the sense that can be an individual liability or a joint liability. Normally in the partnerships, we are expecting all to be the joint liability, because that is a partnership, right? So in joint liabilities, you can see joint liability for debts and obligations. Now whatever the debts and obligations that you have as a partnership, both the partners, or let's say the partners involved, are jointly liable for them, right? And the second one is joint and several liability for wrongful acts, right? If you can remember the vicarious liabilities, right, the joint and the several types of liabilities, right, which can be defined or undefined even for wrongful acts in the partnerships, right, from the partnership to the third parties, right? All the partners are liable for those types of wrongful acts. It can be either a civil wrong, it can be a criminal offense, but you are still liable, right? And joint and several liability for misapplication of money and property. That is actually a fiduciary fraudulent conduct, right? If you have misapplied your money or property, that is a fiduciary fraudulent conduct, which can be considered as a severe criminal offense, right, which are subjected to the criminal offenses of the under the law. So there are joint and several liabilities for misapplications of money and property. You cannot misapply the money and property of the third persons which are being given to you under the name of the partnership. Okay, right. Then liability for debts and obligations, that covers through the section 23 of Partnership Act of 1958. And normally the commercial partners authority is going to buy stock on credit, receive money owing to the partnership, right, and sell stock and other general partnership property, borrow money, that is borrow money in the sense you can borrow the money under the name of the partnership, right, and incur debts in partnership name, pay partnership debts, sign checks, hire employees. These are the normal rights or the normal authorities that a partners have, right? And also, let's say if you have made a mistake on those, right, the third parties or the externals can make the legal actions against you. But under the provisions made by the section number 9 of the Partnership Act, that exempts these two contacts, or let's say these two acts, from the letting the other parties to get the legal actions against you, right? There the partners has no authority to act, right? Let's say, now these are basically the exemptions in the sense, if you haven't done it, but if somebody has done it, let's say there are two partners known as A and B, right? Forget about the word of exemptions, right? Let's say there are two parties named A and B, right? So if A has made a one of these things, right? So he can be sued over the courts, right? He can be sued. I mean, the third party can sue over the A, right? So there, the partner has no authority to act. If you can remember, whenever we were discussing on the laws of agency, we discussed about the authority which is expressed or implied by the agent, right? Which is here, it's also same, right? There's no principal law agent contact here, but of course the partners has to be mutually agreed for their conducts. There, if the partner doesn't have that particular authority to do so, or else under the expressed or implied authority and level, or else the ostensible authority, right? Or even the other partner has, now the partnership in the sense, you both have to approve all these acts, right? If one party has not agreed, in the sense the partnership doesn't exist for that particular act, right? So that will be considered as a voidable act, okay? So there are, partners has no authority to act, or even partner has made such an let's say a performance under the ostensible authority, but though it is under the ostensible authority, the other partner has not ratified, right? Then the third party can take the legal actions against the other partner who has misperformed, right? And then the third party knew the co-partner had no authority, right? Co-partner had no authority. The third party didn't know or believe that the partner was in fact a partner, right? So there, these two conditions make the misacted, or let's say misperformed partner to become liable. That is actually not a joint liability, right? That comes under single liability, or let's call it as that is not the plurality, right? That comes under the single liability. So that particular misperformed partner held liable for all these acts, so the third party can sue over him. Okay. Then liability by holding out or by estoppel. Now in some cases we can say the non-partners of the partnership become liable for debts, right? Now these are the circumstances. Leaving the partnership, care must be taken when leaving the partnership. In certain circumstances, the former partner will still be liable for new debts incurred by the partnership, right? Then the second one is debt incurred after death or bankruptcy of a partner, right? Let's suppose that A and B are partners and they got 50,000 of let's say dollars from a bank, and still the debt partner has the liability on that 50,000, let's say 25,000, right? Equal partnerships. So in that case, another party who's let's say the next person to become the partner of the business is still held liable for the debts which were drawn by the previous partner, right? It can be that B has, once the B has let's say passed away, so that the B died. When the B died, so the B's son would be the next partner of the business if A wants, right? If A accepts. In that case, of course, the B's son held liable for the amount drawn by the A and B. So which means again the B's 25,000 the proportion has to be repaid by the B's son's profits. Okay. then debts incurred before the resignation or admission of a new partner, right? Those are still make held liable to the partners by the estoppel, because by the whatever the condition made by the estoppels cannot be changed, right? The first condition will be considered for the estoppels, right? Estoppels are there to refrain a person from withdrawing the first act of him or her, where if they have made a promise, they cannot reverse the promise under the principle of estoppel, if you can remember. Then, what are the ways of termination of partnerships? Now, there are four ways basically we can say. The terminations can be partners. Termination of partnerships can be made by the partners by mutually agreeing to each other, so they can make themselves by themselves, or even the operation of law creates partnerships dissolute, and or even supervening illegality, right? Whatever in illegal causes the termination of partnership happens, and through the courts, right? In the courts, it can be because of the insanity of the partner, right? Permanent loss of the memory and things like that, right? Or even the permanent incapacity of a partner, right? The capacity means that let's say the capacity is not there for the minors, right? The people, those who are under or below the legal age of the agreements. Prejudicial conduct of a partner, right? And willful persistent breach of agreement, right? One party breaches the agreement, right? Which is not again sort of let's call it as we discussed about the breaches of agreement before, right? So there it's not under the term of repudiation or renunciation, right? That is not repudiation, but still willful breach, right? One has breached one of the conditions, right? So don't make any confusions between the repudiation, renunciation, and this breach, right? It's breach, right? Then partnership can only be carried at a loss, and justice and equitable to dissolve the partnership. So in these circumstances, the partnerships can be dissolved by the courts. Okay. So these are the things that I wanted to discuss you today. Thank you very much for attending to the lecture.